Evans, there is an authority. I've been under a lot of pressure that he needed to say something about it. And he's part of me.
What will be, how will others respond to the authority?
No, he's answering the authorities that were used, cited.
My Lord, just note that he has no right of reply.
No, I'm leaving.
We're in the same team.
In the same team.
My good friend, Mr. Wanyama.
Yes, he's actually filed the application, not me.
Thank you to the court. I am fully aware of the long day that it has been, and we don't take it for granted. Thank you very much. I want to respond to the following issues of law. Reference was made to the other side, attaching affidavits to lawyers on this side. Affidavits belong to the deponents, the Statutory Oaths and Declarations Act. Conservatory orders are constitutional orders. They are aimed at protecting the substratum of the case. It cannot be weaponized against this side. Third, the diary case. What should concern this court is the pertinent fact and the act that recusal happened, and what the Supreme Court said about that recusal. That's all what this court is supposed to consider. My good friend, my senior, Mr. Nyamodi, urged the court to ignore certain electronic material that was presented for the lack of a certificate as required by Section 106. I'll urge the court to take cognizance, number one, of the short timelines, the reflex within which advocates were required to make the returns. In any case, we will endeavor to file the certificate. In any case, I want this court to be persuaded by the decision in BBI that formal rigidities should not supervene, especially in a constitutional context, bearing in mind the exigencies and the demand. Because under the Mutunga rules, we can even submit here on non-epistolary basis. Finally, and as I sit to this good court, and we respect each and every of the judges and our colleagues on the other side, 4 things belong to a judge: listen courteously, answer wisely, consider soberly, and decide impartially. Those are the words of Socrates. Thank you, Your Ladyship, Your Lordships.
Are you withdrawing the application? I think we've come to the end of our proceedings today. We will deliver a ruling tomorrow. Dr. Khaminwa, the problem is I don't know whether you are talking as a respondent because you had spoken earlier. Is there something else you want to add?
The matter we're dealing with is under Article 145 and Article 150 of the Constitution. We need to approach this matter very closely. Don't be tied by rules of practicing civil procedure or what I call it. We are dealing with a delicate matter. That is the security of the country. And if I may say so, I'm going to say so to honor, with tremendous respect. You need the best use of mind and the best experienced people to address your business. It would be wrong to stop you from addressing your business. It's a fact that we are having a much proceed. But, oh, thank you very much. Thank you very much. Thank you very much. My Lord, my own, that you are take most of the apple. I Yeah. We respect our judges. I respect our judges. I have been very privileged in my entire life. I've spent it saying, yes, please, Your Honor, yes, please, Your Lordship. I've interacted with the judges, both at my home, eaten with them. They have invited me to their homes and so on. And I had the privilege of working as a judicial officer, as a resident magistrate in the colonial days. And I had the privilege, rare privilege, of even marrying from judiciary. People serving as a judicial officer are decent people. We may have some isolated cases of some people who are not what we think they should be. But the people on the whole serving the judiciary are decent people. And as a matter of fact, I've said it elsewhere, very loudly too. Kenya is what it is now because of the judiciary. Without the judiciary, you would have something quite different in the country. Judiciary has saved the Kenya, has built the Kenya. We enjoy respect that we enjoy in this country because of, or in the world, because of our judiciary. Our legal authorities by our judges and so on are cited everywhere now, including ICJ and so on. They are cited with approval that they are good law and so on. We respect our judiciary. But my lords and my ladies, if you look at Article 145, when you're considering Article 145 and Article 150, we have to be extremely careful. We have to be extremely careful. This is a matter touching on security of the country. And we cannot afford just to stick to certain procedural things or certain evidential things and so on. The court is called upon to look at things very broadly, very, very broadly. What you are saying to your lordship and my lady, very, very respectful, is that so far as I'm concerned, there's nothing wrong with you at all. But there is a significant portion of the Kenyan population who believe that you are not, with respect to the right people to sit and face this. And I'm saying to you very respectfully, there's nothing wrong. Give us a good opinion, a good judgment of what you're respecting you, and you get out of this case. We do not want protests in the streets. People come to the streets and say, oh, the judges who are biased, the judges who are biased. We do not want that kind of thing. Some of us are too old to leave this country to go to Uganda, or to go to Zanzibar and what and so on, to stay there. We want to stay here and die here. I have gone through an experience which a number of you have not seen at all. When Amin came into power in Uganda, in Kampala, I saw things that were not, which were not acceptable. And I'm saying that, look, let us try as much as possible.
But Lord, at those points of law, I mean, cannot concede.
May I say something? With respect to
Dr. Khaminwa, we will consider what you have said. I think you have submitted, and we have understood you. You have understood your submission. If you want 2 or 3 minutes to summarize, please do that.
You always serve me my God. And also, the professor talked about law. Let me now give him law, which I don't think he knows. My lords and my ladies, I'm asking you to apply a precautionary principle. A precautionary principle is a principle of environmental law. But this principle has now been translated, it is used in matters of security. On our part, we invaded Somalia when Kibaki was in power. because of this precautionary principle. And I'm inviting you very respectfully that you apply that principle, a precautionary principle, when considering the matter under the Article 145 and Article 150. Under Article 145 and Article 150, having in mind the security of the country, so that we do not have protests in the streets of Nairobi, which will destabilize the country and which will put all of us in an embarrassing position. Your Honor, with respect, I'm asking you again, apply that precautionary principle. And when we ask you to get out of this case, we are applying that precautionary principle that we do not want certain evil people in the streets of Nairobi shouting, Hatujapata justice.
That is a threat.
Thank you very much.
That is a threat.
That's what?
That is a threat. Don't threaten us.
What precautionary principle is not a threat. Yeah. Can
My
I
Lord.
sit down, my-
Yes,
I would have
yes.
liked to go on further.
No, please sit down.
And may I say with tremendous respect, my Lord, may I say with tremendous respect, I'm very well aware. Thank you.
My Lords, Your Ladyship, there's one urgent issue that I would like to draw the attention of this Honourable Court to before the court rises. My Lord, in Petition 565, there were conservatory orders granted by your brother, Mr. Justice Chacha Moita, on the 18th of October. But they expire today at midnight. My Lords, the purpose of the conservatory orders were to preserve the purpose of the conservatory orders were to preserve May I continue, my Lord? The conservatory orders preserve the substratum of the petition and the interlocutory orders application in order for the court to have time to consider
Yes, please.
my Lord,
You're listening.
I was waiting for my Lord Murima, not Mulema, to preserve the substratum, to accord the court time to hear submissions on the weighty issues of law of the Constitution. So my plea is that you extend those orders because they were to expire tonight.
Any response?
May I ask something?
Can we get one response only? Just one response.
Yes, my Lord, very briefly. In relation to the question of the conservatory orders, the court will remember that we also filed an application under certificate of urgency on the question of conservatory orders. If at all it is now their changed position that the issue as to whether they can be extended or not should be brought before the bench, we are willing, ready, and able to argue it right now.
Well, these are orders that have been granted. They were enforced. There is nothing to argue. We have not come to the applications. In fact, there are another 2 applications for conservatory orders. And I assume that the application by the Attorney General, the Senate, and by the National Assembly for the discharge of the conservatory orders, you'll be here together with these other 2 applications.
No.
I
I am addressing the court, not the bar.
My lords, if this court is bad for something, it is bad for everything. Until you have ruled on your own suitability to hear the matter, you cannot address any substance.
You are right, Professor Githu. We meet you tomorrow at 1.